Might I start by saying that I think it's very warm in here, so if there is any means by which we can address that, I'd be grateful. It's very stuffy.
Yes.
Thank you. Sorry about that, Mr. Gupta.
Yes, indeed. Thank you very much. So, having heard what your ladyship said at the outset, and my own friend's submissions, obviously I'll address you accordingly, and I appear before you together with my learned juniors, Miss Morton and Miss Gaunt, who's the latter who, of course, is attending remotely. I'm most grateful to Lord Justice Baker for providing that permission. Our essential case on the Article 12 point is this. Parental intention of a parent is a factor when it comes to looking at settlement. We respectfully submit that it's more important a factor, carries more weight, the younger the child is, the more dependent the child is. And I'd ask the court to remember paragraph 57 of Canon, which is at page 28 of the authorities bundle, which, although it's on a separate point, is still, the logic is still there, where Lord Justice Thorpe said a very young child must take its emotional and psychological state in large measure from that of the sole carer. An older child will be consciously or unconsciously enmeshed in the sole carer's web of deceit and subterfuge. Now, of course, the latter point didn't exist in this case. The learned judge, the trial judge in this case, said there was no subterfuge of deceit, but we respectfully submit that this little child, of course, still aged 3.5, takes a great deal of her psychological and emotional state from her mother.
Which paragraph in
Paragraph 57, page 28.
Yes. Yes, sorry, I missed it.
And we're respectfully submit that that's logical. And if you took, for example, a 13-year-old boy who's gone back and forth from Portugal to Wales, his mother says, we're going to go back now. He says, well, no, I'm speaking Welsh, I'm playing a local rugby team, I'm settled. That's a different example, that's a completely different scenario to a child who's completely dependent upon her carer, her mother. And consequently, her psychological state and the settlement of that is dependent upon her mother's decision to settle. Now, I've heard what your ladyship said about the deep dive into the documents, and I'm going to just try and pick out a few vignettes, which are obviously in the judgment itself, the relevant passages. But I'd ask the court to look at the chronology. This is not a child who's been living in this jurisdiction throughout. Because if you look at page 52 of the core bundle, you'll see there the chronology of relevant events. Firstly, you'll see that the mother moved to Portugal, having met the father in Portugal, back in May 2019, and was there continuously until September 22. She's already lived, the mother, in Portugal for 3.5 years continuously. And then, upon removing the child from Portugal in September 22, the child came back to Portugal on 1, 2, 3, 4, 5, 6 occasions. So the time in Wales was punctuated by many visits to Portugal, the last one being of an extended duration, September through to November. And in our submission, a child in that situation, of that age, it would affect what they're thinking and their settlement, especially if their parent is not knowing exactly what they're doing with regards to their long-term future. I say long.
Quite a striking feature of this case, Mr. Cook.
Yes.
I can't recall an abduction case. No doubt you'll be able to tell me, Ms. Gould, tell me if there have been cases in which, after an abduction, or your case, a pretty blatant abduction, the child goes backwards and forwards between the two countries and nobody does anything about it. I can't recall a case like that.
No, the only thing I'm thinking of is anecdotally, I've been involved in a number of Irish cases where it's going back and forth across the Irish Sea, but no. And the reason it's happened in this case is because the parents were pretty much ad idem and trying to avoid court proceedings. And that's a general point that my client, I'm sure, would like me to make. He sees this as a tragedy that he's here in court, trying to organise matters with the mother of his daughter over the years. Him arriving in this country 32 times, we respectfully submit that promotes the child's Portuguese identity rather than counts.
I mean, I know, I've probably seen a thought bubble above my head of why isn't this acquiescence? Because that was raised, and it's not. We're not concerned with that.
No.
But it's quite an interesting thing, isn't it? The father elected not, as he could have done. He could have taken steps as soon as the child lands in Portugal. At any point thereafter, on your case, he could have. On anybody's case, he could have done something about it.
He's not that kind of parent or person. He's not a litigant as such, litigious person. He sought a way of coming to an agreement with the mother, and he thought he'd reached that agreement, which I'll talk about in a moment, of course. And in our section, when one looks at the settlement aspect, a child going back and forth between two different countries with a parent, as we'll see, and you'll have already seen in the messages that she sent, wasn't convinced that she was actually going to be staying in Wales in any event, and kept saying, I'm coming back to live in Portugal. In that situation, the child, on the facts of this particular case, on the unique facts, arguably, wasn't settled.
Was there any evidence, not on your instruction, was there any reference to Hague Convention or abduction proceedings before they were launched this year?
Not as far as I'm aware. I'm sure I'll be corrected if I'm wrong, but the parents were talking. Father was coming over. As the CAFCAS officer said in her report, she saw contact. She saw the fact that the parents were liaising very healthily in front of the child. And I wanted to point out paragraph 63 of the judgment in the court below. That's to say page 92, electronic reference. It's the last line that my learned friend took.
Sorry, the last line of paragraph.
63.
Thank you.
Page 92.
Yes.
The last line of that judgment, which my own friend, that paragraph my own friend had took issue with. I accept that it's likely that B will have picked up on Mum's lack of settlement. In any event, it cannot be that B has become settled when M is not. It's child specific. It's to do with B, the circumstances of this case.
It's not a general proposition.
Not a general proposition. It's not saying it's automatic. It's axiomatic that when a parent's not settled, the child won't be settled. Because as I said when I gave that example of the 13-year-old Welsh rugby playing prodigy, in that situation, the child would be settled and be saying, sorry, I'm settled here. And there would be objections, for example, would be another potential defence. But in this particular case, with all the other factors that are embedded within this judgment, in our submission, this learned judge was quite right to come to the conclusions that he did. And of course, another initial general point I'd like to make, which is paragraph 71 of his judgment, page 93, starts with, if contrary to my conclusion, B was settled in this jurisdiction at the material time, my discretion will be at large. And of course, he backs that up later on with effectively saying, if I'd found that, let's pay at paragraph 88, if I'd reached the conclusion that B was settled in this country, then on the very unusual facts of this case, and which include that, etc., I would have exercised my discretion to order a return to Portugal. So that's a hypothetical, arguably judicial belt and braces approach, which is actually, I don't find the defence, the gateway laid out in this case. Now, in our submission, the gateway in settlement cases is particularly important. And the reason for that is because the discretion to return once settlement has been found, you hardly ever see it. It's like hen's teeth. The only example is Mrs. Justice Black as she was in F against M. And what Miranda Jr., Miss Gaunt, did on the last occasion in the court below, if you look at the supplemental bundle, is you'll see a table of Article 12 cases, 5 pages of international research that we conducted to try and see if there's an example of settlement being found, but the child nevertheless being returned. I'm afraid we drew a blank. It's a discretion.
Am I right? I think I said to Ms. Gura this morning, in some jurisdictions they don't accept that there is a discretion.
Yes.
This is discussed in the textbooks.
And this was touched on, or dealt with in detail actually, by their lordships in Riem, Zimbabwe. But just turning to that schedule, you'll see there.
Which page was it?
This is at page 41 of the supplemental bundle. A number of cases there where the first column is the name of the case, the second column is has settlement been found, and what you're looking for is a yes and then a yes in the third column, still nevertheless returned. All we kept turning up was yes and no. Yes found, not returned.
Ms. Gaunt ought to publish it in family law.
Yes. And settlement often, anytime it's found, obviously the defence isn't made out.
Sorry to be tedious, but I'm just looking for yes, yes, and I found it on page 45. I don't know whether you can tell me.
Yes, that's the one that I mentioned.
The Mrs. Justice Black.
The then Mrs. Justice Black.
Oh, I see. Sorry, forgive me.
It's in the bundle.
Arguably, in authority, it should have been appealed because what she did was she ordered a summary return, but then stayed it for a number of months for the respondent mother to start her Polish permission to relocate case and try and get interim permission to relocate. So that's the only one we could find in Dijon.
So, what do we conclude from that?
It's an important decision whether or not the gateway is found on a settlement case.
Because once the child is settled here, would this be a fair way of looking at it? A decision whether or not a child should be returned has to be a welfare decision.
Yes, pretty much. Has to.
And it may be a abbreviated welfare decision, but it has to be a welfare decision. Do you accept that?
Welfare is relevant, but you're still working within the auspices of Hague, so it's not paramount. It's not a welfare decision. We turn to Riem.
Yeah, that's what she said. Wasn't it?
Yes.
She said that, it's not always.
Yes.
Um,
This is an authority that rings bells because I was in it and we were arguing on behalf of the children that discretion doesn't exist. Once you get through the settlement,
Yeah.
children had been in England from Zimbabwe for a number of years, spoke with Yorkshire accents, and we were saying, well, no, discretion doesn't exist. But what you'll see there is only one of their lordships was with me in
yes,
that
Lord
argument.
Roger, was it?
Yes, and the rest of their lordships were against that decision and went with Canon and Canon and said, no, the discretion still exists.
The passage is paragraph 44, isn't it?
Yes,
The last two sentences, that's what it's not a paramount case. The welfare extent to which it's appropriate will vary. The further one goes away from speedy return, the less weighted the convention consideration.
yes,
So that,
but it's still not a paramount welfare. When you said welfare decision, I immediately thought Children Act, paramount welfare. No,
so that's wrong.
it's
In
the
practice,
yes.
there's only one case which you say should have been appealed.
In my submission, yes.
In which welfare
was in that case, yes.
in which a child was returned despite
Wasn't returned immediately. So that's why the decision about whether settlement is found as a fact, which Aristotle is a matter for the court below, having sifted through all the evidence and gone through all the arguments the way that the judge did.
Someone
diligently.
says it's the focus is welfare. Mr. Justice Williams, I think he says the focus of settlement is welfare. One of the judges.
Yes. Well, I'd respectfully submit that the decision of Mr. Justice Harrison is a very interesting one. That was before the learned trial judge. It's probably my fault for not highlighting that paragraph 49, which is in the authorities manual at page 211, because we went off on a different tangent, which is when is the settlement? Is it the
Yes,
beginning?
I confess I'd only looked at Mr. Justice Harrison's judgment on that point. I hadn't until
That's. I'm afraid that's what I found
I
as
hadn't.
well.
You say, what do you want to say?
Paragraph 49, my submission, is good law because his logic is, with great respect to Mr. Justice Harrison, impeccable. If I'd invite the court to read that paragraph.
That's about habitual residence, the distinction.
Yes. So if you can lose your habitual residence in a day and turn up with suitcases and gain it in another country in a day, it doesn't mean that you're settled. And so that's why the learned judge is saying that actually a greater degree of integration is required for settlement than it is for that habitual residence.
How does that help us? Because we were talking about welfare and discretion.
So in my submission, the reason I'm raising this now is having pointed out how important it is in practice to decide the decision about whether settlement has been found as a fact or not, because if it's found, there is effectively a limited use of discretion. One then has to look at the actual test for settlement and see how, what the degree of integration needs to be reached. It's not simply a low bar. Habitual residence, it seems, my submission, this is correct, is a lower bar.
But what we were thinking about, or what I was thinking about, perhaps erroneously,
Yes.
was what are the factors when you're exercising that discretion once the settlement has been, there's a positive tick, there's a yes in the settlement column, and one is looking at how to exercise the discretion in the next column of that wonderful table, and you say welfare is not paramount, but
it's one of the factors. So
Okay,
if the
but what are
court
the
looks
other
back at the
factors?
judgment, page 93 of the judgment, you'll see there that paragraph that I mentioned, 71, if contrary to my conclusion,
Yes.
discretion is at large, it then goes, learned judge then goes on to set out what
Baroness
Baroness Hale said
Yeah.
about the exercise of discretion if the settlement is found.
And I should imagine, therefore, you're content with everything she raises there.
Yes, I am.
Good.
So you would be, if we were against you on ground one, you would invite us nonetheless to say that we should uphold the decision and double the number of cases in which, worldwide, in which...
that we're aware of, yes. But as I say, that it's not a low bar when one's looking at the defence of settlement. It's also to do with, of course, the wording of Article 12 itself. Trying to find a place where you can see it easily. If you look back at Riem Zimbabwe, page 458, right at the bottom, the basic obligation to return the child is spelled out in Article 12. I'd like the court to read that paragraph. That is Article 12. Right at the bottom of 458.
I should say, although, of course, given the size of the authorities bundle, I'm not suggesting that it should be even more voluminous, really, but it would have been helpful to have Articles 12 and 13 in the bundle.
I apologise.
It would also, because mine has broken, have been helpful to have had separate volumes of the authorities. I think next time I will look at them online.
Yes.
Anyway.
And I apologise for that because I found myself looking up, not the Hague Convention, and thinking I should have put that in the authority one. Apologies for that. But you see there, and of course there'll be many phrases in the article in its entirety that your lordships and my lady will look at, but I'd ask the court to focus particularly on shall also order the return of the child unless it is demonstrated that the child is now settled in its new environment. So it's got to be demonstrated, burden of proof, and the standard of proof we respectfully submit is, as I said earlier, on higher than simply saying, well, habitual residence has been gained as it can be in a day or lost in a day. And the factors that the learned trial judge looked at, he of course set out the mother's case on that point in its entirety, and you'll see that, you'll have seen that. I think it's paragraph 50 where he's gone through all of her points. Paragraph 50, page 89. All these factors are the factors that the mother said were in support of settlement. What my learned friend said on the mother's behalf is, well, he then just cursorily dismissed them over in a few lines. Well, I don't understand what further he's supposed to do in a summary judgment, apart from, say, go through them individually in a sort of tick box exercise. No, he set them out. There was no, apart from typographical corrections, as far as I'm aware, anything else sent through to the learned judge for him to clarify his thinking on any particular point. When the draft judgment came out, of course, it has to be remembered that this draft judgment came out a few weeks before the finalised judgment. Draft circulated 24th of June, and approved judgment 4th of July. But going back to paragraph 50, everything is in there. The learned judge has considered it all, and then turns to the arguments on behalf of the father, and has it all set out in his analysis, having set the law out, of course. So in my position, he wasn't wrong in law, and he wasn't wrong, of course, in applying his application of the law to these particular facts, these unique facts. How often is it, as my Lordship Lord Justice Baker just said, the child goes back and forth between two countries so many times after a mother has removed a child. Surely in that situation, and here I'm going to give a photograph, show the court a photograph, surely in that situation, a child will not feel settled in that jurisdiction in England.
Well, is that the question? The phrase is new environment.
Yes.
And yes, I'm struck by Mr. Justice Harrison's point, as opposed, how do you put it in paragraph 50?
Yes.
Where is it now, Mr. Justice Harrison? I've lost him. The primary focus of the question whether the settlement's been achieved, quotes, in a new environment,
Yes.
quotes, as opposed to with the abducting parent.
If the court looks at page 203 in the supplemental bundle, and here I'm going to do a shallow dive into some of the documents that were before the trial judge, you'll see there a photograph of mother turning up in October of last year with the caravan and everything else in Portugal.
How does that help us, Mr. Gupta?
Sorry?
How does that help us, Mr.
Well,
Gupta?
my submission, a child arriving of this age arriving in those circumstances, back in Portugal, having been there for a number of occasions, would not be thinking, well, I'm settled in Wales. Be thinking precisely the opposite. Her emotional and psychological state would be probably thinking, I'm settled back in Portugal. Anyway,
Her environment, over the 2.5 years prior to the issue of proceedings, the environment in which she lived was living principally here, but with frequent visits to Portugal.
If one looks at the chronology of it, there is more time, absolutely more time spent in Wales than there is in Portugal. But in my client's corrected a percentage. He said it's 39.5% of her life was in Portugal. Be that as it may, I don't think most exposition you can phrase it that way. Visits to Portugal immediately makes one think, well, the fact is established that she is living in Wales. The circumstances in which she's living in Wales cannot be forgotten. If one looks at the Kafkas report, page 260 of the supplemental bundle, this is the circumstances that she's living in Wales. Portable chemical toilet, separate bedroom, house has mains water but no other mains power. And then the Kafkas officer says it's homely and appropriate at present. However, she appears content and comfortable there. However, there are elements of the home which mean it's unlikely to be a suitable long-term home as the child grows up and requires more independence. Lack of indoor toilet and only having one bedroom. That's the nitty-gritty of the circumstances in which this child has been in Wales, and we expect to submit that physical, material point should not be overlooked, that actually it's not a stable, long-term environment, especially if the child is going back and forth from Portugal.
But do you accept it's her principal home? Her principal home was in Wales. That's where she went to nursery and the forest school.
I take issue with the word principal. She spent more time in this environment in Wales, chronologically, than she has in Portugal. But she has a home in Portugal, where she moved to, again, in October of last year, because the mother rented a place there. So, as of October, what was her principal home? The minute one says principal, if I accept the word principal, then of course one's saying, well, she's settled in one place and she's visiting the other place. We don't accept that she was settled.
Well, she's living with her mother most of the time in Wales. A significant amount of time in Portugal, and having regular contact, well, having regular, of course, wrong adjective, but whatever adjective you want, frequent contact with her father, some of it on a staying basis.
Yes, and on that latter point, of course, that shouldn't be counted against the father's case in our situation. He's doing what any parent would do in that situation, is to see his daughter as much as possible. The advantage to this little child, of course, is that she speaks Portuguese, and that Portuguese element of her life has been kept alive. And if we carry on in the Kafkas reports, you'll see at page 266, that's where the word limbo comes up, which Lord Justice Birss was mentioning earlier on. The word limbo comes from the Kafkas officer, top of the page. Child may therefore feel a sense of limbo and insecurity whilst waiting and anticipating a further move in the near future.
Yes, that's on the premise of this point, the father's case. That's what she's talking about in paragraph 50.
Yes, and if you go further down, the mother accepts that the father's been mentioning Portugal to the child, resulting in the child saying at times that she wants to go to Portugal. And if the mother's account is true, this is the Kafkas officer, if the mother's account is true, child's father's comments about potential return may have kept her from feeling fully at home in Wales. We respectfully submit that. Again, that counts as against emotional settlement, psychological settlement. Going back to the original point that I started with, which is the intention of the parent having an effect, more of an effect, the younger the child is. As my Lord Justice Birss mentioned, it would be used the other way around, of course. If a parent says, my client had said it's my intention for the child to remain in Wales, and of course that immediately would have meant probably a change of habitual residence as well as a settlement. He's never once said that. Tried to negotiate a return, thought he'd reached that agreement. But if we look at what the mother herself has been saying, going back to that photograph, the previous page message from the mother, this is October last year. The place is lovely, we're settling in. This is page 202. And those are all aspects and vignettes that the learned trial judge was entitled to take into consideration when he was looking at whether this child had been settled in another country, in Wales, when her mother's saying, we're settling in October in Portugal. So, again, we respect this, but the facts are there, the evidence is there for the learned judge to make that factual finding. And you'll see the mother's lack of focus when you see at page 190 her message of June of last year. Basically, I'm agreeing to move back in January, etc., etc. And of course, December 2024, 215 in the bundle. As already has been said, coming to Portugal, I commit to start to come to Portugal for a 6-month period per year, as I've already shared with you.
Mr. Coulter, we've seen all these,
yes,
and the judge points them out, and it's a question of how he should have dealt with these things, or whether he's dealt with them properly.
Yes, indeed. In my submission, he's the best person to have dealt with it. And oral evidence wasn't heard in the court below, but he was perfectly entitled to reach the conclusion he did on the evidence that was before him. And the Court of Appeal, with great respect, is not the place for these issues to be drawn out again. Within the range of decisions that he came to, he was perfectly entitled to come to that decision. And to say otherwise steps away from the evidence, and I'm sorry I've laboured that by pointing out certain passages in the evidence. There's just one last point I'd like to mention from the original trial bundle, which is my client's statement at page 151, paragraph 93, which actually talks to the child herself. Paragraph 93.
But none of that, I'm not belittling it at all, it is your client's statement, but I don't recall any of that being reflected in the Kafkas report. Am I right?
It wasn't reflected in the Kafkas report, but the learned judge had that evidence in front of him.
Yeah.
And we respect to submit that shows child not psychologically and emotionally settled where she is.
But he doesn't refer to that directly, does he?
He doesn't.
No.
He doesn't refer to that in his judgment, but he had that evidence in front of him, and it's not there in the Kafkas report, save that which you've already read.
Thank you.
So, in short compass, with regards to the decision concerning Article 12, as I said, I'd invite the court to reinforce the decision, the logic, if I put it that way, of Mr. Justice Harrison in Re GB, as I pointed out, I think it's paragraph 50. And because it's even more of an integration that's required, deciding that really the learned judge was right in the court below in this case to find that it hadn't been established. And then we don't enter into the discretion exercise. But of course, belt and braces, he goes there, he looks at discretion, as did the learned judge in AX, which is Mr. Justice Peel, or Robert Peel, Queen's Counsel, as he was then, where he says at paragraph 39, in that case, page 186, you don't need to turn it up, given my findings on the defences of settlement and grave risk of harm, I do not strictly need to consider the exercise of my discretion. Full stop, however, and he goes on. And this learned judge went on to consider his discretion, and in this trial, in this case, of course, and decided that he would have still exercised it in support of a return. And this is something this court may or may not want to touch upon, which is, I think it's paragraph 88 of the judgment in the court below. Let me just turn it up. 84, beg your pardon. And that's, as I said, something the court may say, well, it's outside the realm of this case, doesn't need to touch upon it, but of course, here we are in the cause of appeal, the civil cause of appeal, where parties are pushed towards alternative means of dispute resolution. And that's exactly what my client tried to do, and he says successfully. I have Portuguese signed copies of that agreement that was entered into in October of last year. And the passage of time to reach that amicable solution shouldn't be counted against this child, in my submission. She's so young and was not settled. And consequently, the learned judge was quite right to just touch upon that policy point.
But surely we are in this determination, or the judge was in this determination of settlement, inevitably child-focused.
Yes.
Of course, you say, and that much of the child's thinking, to the extent there is thinking or feeling
Yes.
about these things, is to be derived from the carer.
Yes.
But whether or not there is a passage of time because of mediation is irrelevant to the child. All the child knows is that is time is passing and whether they are becoming settled or not. It doesn't matter whether they were mediating or looking for a rocket to go to the moon.
Well, in my submission, it is logical to conclude that if both parties are mediating about when to return rather than if to return, that the child's going to pick up on that.
Sorry, the child
is going to pick up on that.
Yes. We're now
Yes.
discussing the matter on the premise that the child is settled. That's where we are now.
If, yes.
If
Hypothetical, yes.
On the basis,
Yes.
if you're wrong on ground one,
Yes.
you say the judge was right, would nonetheless have been right, as
Yes.
he did,
Yes.
to return the child under discretion.
And it's a rare decision, a rare case.
And your point, and that's the context which we're considering, the weight, what weight, if any, should be attached to the fact that they were endeavouring to mediate.
Yes. And reached a concluded agreement, which was then signed by them. We only have let's say the English version. I can't imagine your lordships of my lady would like to see the signed Portuguese version. But of course that agreement, which you can see as an example at page 211 in English, talks about travelling abroad. The mother is hereby authorised by the fathers to go to the United Kingdom for a maximum period of 28 days, twice a year until the child's 6 years of age. These things were all thrashed out and agreed and signed. Mother's case, of course, is, well, now I felt under pressure. But then, of course, she was in Portugal at the time, travelled over with, we say, many of her belongings.
Can we just look at paragraph 84 again, which you've asked us to look at?
Yes.
And what he says, what the judge says there, is that given the obligations and the overriding objective of due justice, it will be contrary to that duty to hold that the arguments in favour of the non-exercise of the discretion were strengthened because proceedings weren't issued earlier because the parties were in mediation. Oh dear.
And whichever way this appeal goes, I would invite the court to consider that point, because that's something that litigants and charities such as Reunite, who engage in mediation for parents over cases of unilateral removal, need to know. Is it really an absolute time-specific point? Is it best to issue first and try and mediate later? Doesn't that blow up the whole process?
What we're doing, what the lease which is being dealt with justly,
Yes,
is what? It's the proceedings under the Hague Convention,
indeed.
and those proceedings are speedy return proceedings. What are Article 1? That's the essential justice, isn't it?
Yes,
The welfare jurisdiction of the court, which governs everything we do with children, is set aside in the circumstances of Article 1.
but this is not simply time is an important element in this particular case, of course. But again, it's not an automatic cut-out point, which is as soon as you've gone past the year, especially in the facts of this case, and the parties have tried to mediate, that actually it should count against, I would respect to admit, the child. Because as the court knows, the overriding objective, if we can put it that way, of the Hague Convention is to protect the welfare of children who have been wrongfully removed or retained. Mother's position throughout has been, up until these proceedings pretty much began, was vague in the extreme, and I've touched upon, of course, the evidence that was in the court below, and there's even an email from January of this year referring to a mixture of dates and months that the child will be in either in England and Wales or Portugal.
The objective of the convention is to secure the prompt return. That's
And all I can do is rely upon greater minds than mine, if from the Supreme House of Lords, who've decided that discretion exists. So I'm inviting the court to exercise that discretion, rather than just see it as some kind of withered limb that's never used. It's there. So surely the facts of this case, in my submission, it needs to be employed. Otherwise, if we're now into this discretionary element, and one's into that scenario, then this will just be another case where the court says, well, never been used, as far as we're aware, only once in a delayed or stayed summary return case in front of the then Mr. Justice Black, and even in a case where the parties were trying to sort their issues out without going to court, which, in my suspicion, all courts should promote, especially in family cases, that it somehow counts against the child in that situation. International case, child going back and forth between countries, father not agreeing, acquiescence not raised as or not promoted as a defence, agreed that child has been wrongfully retained. Article 3 is accepted by the respondent mother in the court below. So we are into the world of Article 12 and 13. So in that situation, the child has, it's been accepted, been wrongfully retained in England and Wales. So again, the policy of the convention shouldn't just be focusing on one word, which is the prompt return. Maybe it is the prompt return because mother only set out her position earlier on this year about not returning the child to Wales.
I don't think you can describe this as a prompt return, can you?
Well, considering the child was in Portugal up until November of last year,
That's not the date.
back and forth.
Prompt return for the date of retention.
Yes, well, we respectfully submit the retention indeed. The child was habitually resident at the time of retention, which was years ago, and unfortunately, the process of mediation, the process of reaching a consensual agreement, as I said numerous times, which was reached, took some time in situations where the mother kept changing and moving the goalposts, and still was up until her application in the court below, and that's to say her Children Act application, where she was still saying a number of months in Portugal, a number of months in England, etc. So in that situation, going back to the Article 12 point, we say it's not made out, and we say discretion, should, even if it is, should be exercised for return. Do you want me to address you on the Article 13b point? We respect him, and obviously the judge was correct.
No, thank you very much.
And of course, the trial judge, then didn't move on to discretion because he said it wasn't. If he had, Mark's exhibition, he would have still ordered a return because everything that he said earlier on in his judgment about the exercise of his the hypothetical exercise of his discretion. If you could just bear with me one moment, I'll just check to see if there's anything else. Yes, and you'll see from paragraph 75 onwards of the judgment of the learned judgment below, page 95, the arguments that were put forward for the court to exercise its discretion for the return, the learned judgment paragraph 76, weighing those up against the mother's arguments, being very fair and diligent about it, and then deciding that he would have nevertheless exercised his discretion for return at paragraph 88. And going back to that point, the withered limb point, there's no point in having that discretion unless it is exercised, otherwise it's just an academic. Futile.
I know I said earlier on we weren't going to decide, for my part, I was attracted by the idea of deciding who's right and who's wrong on the dispute at first instance. It sort of has a relevance here, doesn't it? Not on the facts of this case.
Well, then we're in the realm of the Court of Appeal deciding whether to or to not deal with it at a particular point. Is entirely, of course, up to your lordships and my lady to go there. As I said,
I think we decided not to do that. But
yes.
Obviously, if proceedings are issued, if the relevant date is the date the proceedings are issued, then that will cut out a whole lot of cases where it could be argued the child is settled.
Yes.
And
if it's the alternative argued when the hearing is, then of course that will mean that many potential respondents would potentially delay matters. Maybe they'd mediate to delay matters. And the 6-week rule, which, as the court knows, is the court below tries to observe the 6-week rule for Hague Convention proceedings, it usually takes 2 or 3 months, would be under a great deal of pressure if people could try and gain advantage of a decision of this court saying, well, actually, it's the date of the hearing that one decides whether a child is. There are many Hague cases that begin on the cusp of 12 months or 9 months in or something, and then what does that mean? One can argue settlement after that, and if you can get settlement, then as you know, discretion is hardly ever exercised, never, for return. So there are many policy reasons why one could say that surely it's the time that the proceedings began. The court is seized with the application for return. How the court deals with it, how quickly it deals with it, is a matter for the court, and the court can, of course, have oversight of any mediation process. But such is the pressure on the courts below, it's in my suspicion, it's a bit of a hostage to fortune to say that it's...
So there's a strong argument for
hearing begins.
At the time the court is seized.
Yes, indeed. That may not be a legal point; it's more of a policy point, but it is something that I beg to differ with Mr. Justice. I don't want to say Lord Justice, Mr. Justice Mostyn, and I think it was Mr. Justice Williams, wasn't it, who both said, was it Harrison, who decided that actually it's the time that the hearing.
Harrison.
Yes. Yes. So if I could just turn my back forward. One last point, which is the word permanence, which Your Lordship, Lord Justice Baker, highlighted. In my submission, that's just the same as the word long-term. The learned judge may have used that word, but nothing really particularly hangs on it. He's not talking about a change of habitual residence, because as I said earlier on, pursuant to Mr. Justice Harrison's decision, I suggest that really there has to be clear and cogent evidence of settlement, because integration has to be to a higher degree. Can I assist my lady, Your Lordships, any further if I have been of any assistance, that is?
Well, there were two other points, one of which was out of the attendance note, the agreed note, about
yes.
whether there's anything you want to say
Yes,
about the way in which the expert was portrayed in the judgment.
Well, the only difference in the note was at page 8, where my, I think it was my instructing solicitor's note. So this is page 8, about the centre of the page, where it says it can be done immediately. When I ask the expert, the question is whether she can use the process to apply before she goes back. The answer is it can be done immediately now. That can be done immediately because of all those things now electronic and advisable to do that as fast as possible, etc. The amendment is, or our note was, yes, the application could be immediately. I think it's advisable to do it as fast as possible. It should be done with support from someone who knows what they're doing to make it more likely that her requests are successful, and ideally before the end of this month. That's the only difference in the note. And on that subject, of course, I point out this lady lived in Portugal 3.5 years, has been there many times, and it's about the soft landing. We respect so much. She can, of course, go back on the passport she has. She has a child who's got a Portuguese passport and can sort things out. My clients, or maybe this is fresh evidence, has already paid the sum that he said he didn't pay to this immigration firm to ensure that she's able to get her permission extended or apply for the second permission on the basis of her child is Portuguese. Your Ladyship said there were two points.
The last point on which you might wish to make submissions was in relation to the undertakings and the way that they were treated.
Well, my client says that he's abided by his undertakings. There were a number of properties that were offered from recollection in Portugal, because my client has family and friends who have holiday lets in that part of southern Lisbon, and so he's been able to find properties, but I don't think there was anything.
It was just, I think, the point that was made was in relation to whether there should have been an order.
Well, we respectfully submit it's a 1996 Hague Convention country, and it would be observed in Portugal. Plus, of course, there's this point. My client is likely to adhere to his undertakings, if I can put it that way. There's no finding that he would be a person who would breach his undertakings. There's no risk there. In any event, it's the 1996 Hague, a separate international instrument which we say bites in this case. And to say that undertakings, it's not a non-Hague country, a country where the court, I'm sure the court's been involved in many of these cases, that it's all a bit nebulous. This is a EU country where the 1996 Hague Convention bites.
Thank you very much.
Thank you very much.
Skuha?
And only very briefly, 2 points to remind the court that in looking at the a degree of settlement that's required. The principles are that complete settlement is not required, and that was cited in judgment at first instance at paragraph 47, page 88 of the bundle. It's paragraph 42 of Mr. Justice Williams' decision in AH and CD. And in respect of the policy issues that were raised about mediation, of course, there is the opposite side of the coin, because particularly in Hague Convention cases, it's an extremely polarised position between two parties. So on one hand, it was argued, and the judge agreed, that a father, an applicant, would be penalised by mediating, and therefore the clock would be running and they would face a settlement defence. But the other hand, for a respondent, they could be discouraged from mediating, because the legal advice could be offered to them that if they do enter into discussions and protracted discussions with the other parent, this could deter a finding on settlement. So the whole picture has to be examined. If I can assist the court any further on any other point. Thank you.
No, thank you very much indeed. Thank you to everyone, both those who have provided us with their submissions and those who have worked on the matter behind. As you'll be well aware, in this court we do not just hand down our judgments, we circulate them. Of course, that's what we will be doing. We're not deciding today. And those drafts are for the purposes of obvious typographical errors and not for the purpose of re-argument. Thank you. When the matter is handed down, it will be handed down electronically. Please be terribly careful before that, also to be aware of and to comply with the rubric in relation to the persons to whom the draft is circulated. At the time that you are looking at the errors that we've made in relation to our grammar and other matters, please would you also see if you can agree an order between you in relation to consequential matters. And if you can't, please provide us with very short written submissions about the differences between you, and we will decide that matter on the papers. Thank you very much indeed.
All right.